Making decisions based on misguided assumptions about revoking and reinstating wills often leaves survivors to fight over the estate once the testator passes away. When a woman executes 2 wills during her life, her friends and relatives become embroiled in a battle of wills, in re Estate of Alburn. In Milwaukee, Wisconsin, Ottilie Alburn executed a will and left the original with the attorney who drafted it. Under the Milwaukee will, Ottilie left most of her estate to her grandniece, Viola, sister-in-law, Lulu Alburn, friend, Olga Olson, and her late husband's relative, Doris Alburn. Under the Milwaukee will, Doris and Lulu were each going to receive about 1/4 of Ottilie's estate. Then, Ottilie moved in with her brother, Robert Lehmann, who lived in Kankakee, Illinois. There, Ottilie made another will. This will left the bulk of Ottilie's estate to Lulu and Doris. 1/10 went to Robert. Next, Ottilie moved in with another brother, Edwin Lehmann. Edwin asked Ottilie about the Kankakee will, and Ottilie said she, quote, got rid of it, unquote. Ottilie brought Edwin the torn pieces of the will and told him to dispose of them. When Ottilie died, she left behind 5 siblings and numerous nieces and nephews. Ottilie's sister, Adele Rudisili, filed a petition and argued that Ottilie died without a will. Viola petitioned to probate the Milwaukee will. If Viola won, Ottilie's property would have been distributed according to the Milwaukee will. Lulu and Doris petitioned to probate the Kankakee will, using a carbon copy. The county court held a hearing. A relative, Olga Lehmann, testified that after Ottilie destroyed the Kankakee will, Ottilie said she wanted the Milwaukee will probated. The court granted Lulu and Doris's petition to probate the Kankakee will. Adele appealed to the Wisconsin Supreme Court.